Welcome to our third presentation covering employee privacy. When we were last together, we discussed, or actually our first two times we were together, we discussed kind of an overview of the issue of privacy in the employment relationship. We talked about the reasonable expectation of privacy, a concept, by the way, that will also be front and center in this presentation. And then we talked about, in our second presentation, constitutional and statutory issues. In this presentation, we're going to cover common law issues because even though we're just covering one topic in this lecture, it is the rock star in this area. This is where most of the activity is, especially when we're talking about private employers. So let's get started. I'm going to go ahead to slide 34. And you can see we're ready for common law issues. So we're focusing here on the private sector. It does this when I say that the private sector is most important in this area. I don't mean to say that government employees can't advance common law tort claims, but they're more likely to use constitutional arguments. Usually there's a little bit more purchase with those types of areas of the law than you'd find with the common law. Both are available, but again, since the primary focus of this class is on the private sector, this is really where the protections for employees are going to really shine. And as we're focusing primarily on the position of the employer, this is where savvy, sophisticated employers can protect themselves. And so much of the work in this area that savvy employers do from an HR perspective is to limit or reduce that possibility of successful lawsuits in this area. And there's lots of different strategies that can accomplish this. One is by making good employment decisions. If you make good employment decisions, most of the time you are not going to find yourself losing tort claims. And so making good decisions that are well documented and supported by the facts of the case after a diligent investigation is probably the most important way to protect an employer from these types of claims. Other things to keep in mind, though, are that an employer wants to make sure that its culture is being respected and honored. Culture is kind of a funny thing. It's, in some sense, a thing that develops in its own, having to do with the personalities, temperaments, business model that a particular employer has. But it's also something that the most senior managers in the HR department have a strong ability to affect, to guide, to nurture, to shape. And so being aware of the culture you want within your organization can also inform how you approach many of these issues. So let's get started. Go to the next slide. We're going to first of all do a little reminder about employment at will. This is that notion that undergirds everything we really talk about. And again, this is a private sector issue. A fairly significant portion of governmental employees are not employed at will. So again, we're focusing on the private sector. In those cases, most individuals are going to be employed at will, meaning that they can leave their employment at any time, and also the employer is entitled to end the employment at any time, really for any reason except for an unlawful reason. I know in this course I spend most of these videos talking about various scenarios where the employer does this or that, and I say, oh, employer can't do that, nope, employer can't do that, no, employer can't do that. And so it may start feeling to you like an employer is really hemmed in and there isn't a lot an employer can do. I apologize if I've given you that impression, because actually the reverse is true. Employers have a tremendous amount of latitude in deciding who to hire and who to fire, who to promote and who to demote. All of those issues, the employer has a great deal of latitude to make good decisions, to make bad decisions, to make smart decisions, to make dumb decisions, to make fair and equitable decisions, to make unfair but still lawful decisions. There is a tremendous amount of play here, and really there are just very discrete areas that the government says, oh, you can make a stupid decision, but you can't make that stupid decision. So keep that in mind when we talk about these things. Unless you can point to a particular law that is being violated, an employer is entitled to be a jerk. He's entitled to make stupid decisions. The law doesn't protect the employer from himself and doesn't protect the employee from an employer who's just stupid, as long as the behavior is not unlawful. Okay, let's go to our next slide. Tort. We're going to be talking about torts really throughout this category. So when we think about privacy law, as I said before, common law is the area that we really see a lot of activity in the private sector. So what is common law? It's probably a term that you've heard before, but you may not really have a good grasp of it. Well, this is law that is made by judges. It is not a statute. It is not part of the Constitution. So when a judge renders a decision in a particular case, he or she is adding to this body of law that shapes and molds and creates the legal foundation that we have. We in Texas, and really all of the states in the United States with the exception of Louisiana, are common law jurisdictions. That means that the role of judges is kind of is very, very important to the foundations of our legal system, to the creation of law. Yes, we have legislatures, and they certainly pass laws, and that's an important part of the law. But there are big, big gaps in our legal system where our legislature really hasn't passed any laws. And that usually is kind of a conscious decision on the part of the legislature, at least to some degree. Because what the legislature is saying is, you know what? Our judges have this under control. They've developed a system over hundreds of years in this area, and we're just going to let them go for it. And then sometimes a legislative member might say, oh, I don't like the way that recent decision was decided. And so the legislature then passes a statute that says, no, we don't like that. We want the law to be different. So when the legislature comes in and creates a law that contradicts or is in some way inconsistent with a common law concept, the common law concept goes poof. It's no longer the law of the land. The common law is a placeholder until the legislature acts. But most of the time in our system, the legislature is not going to act. Now, I know there's this belief out there that, oh, our legislature is, passing laws upon laws upon laws all the time, and there's all these laws. Well, there are a lot of laws, but we don't have we don't have many areas of law that are highly codified. And tort law is one of those areas. Almost all of tort law is common law. And so when we talk about common law and we talk about privacy, we're really talking about, we're talking about privacy, we're really talking about common law for the most part. And we're talking about issues of tort law. So let's pause and talk about tort. You may, when you hear the term tort, think a delicious Austrian chocolate treat, right? Sacher torts or something like that. Well, this isn't quite so tasty. This is a concept of the law that has to do with a wrong that has happened. This is the definition: a private wrong in which one person, in this case it's the employer, causes injury to another person, the employee. Many times we have another term that will be added to a tort definition. They'll say a private wrong not arising in contract in which one person causes injury to another person. You can see this definition isn't very satisfying. Well, gosh, whenever I do something that another person doesn't like, I've committed a tort? Is that what that means? No, not at all. It's a much more focused meaning than this very vague and very broad definition gives one a feeling for. But it's a little bit like defining the word red or defining the word thee. These are such basic terms in the English language. Any word that you use to define or describe red is actually a more complex word than red, right? And so if your listener doesn't know what the word red means, the odds that they will know the words that you use to describe red is even less likely. And so in some sense, you can't define red. I mean, you can show someone red, but you can't really get into a definition that's helpful at all. That's similar to what the idea for tort is. Tort's such a basic idea in the American legal system that it's a basic starting point. So to define it really requires understanding more than the idea of torts. You really have to have a pretty sophisticated understanding to then go back and make sense of the term torts. So this is the definition we're going to use, but I'm not defending it. I'm not saying, boy, this tells you all you need to know. But as we dive into this topic of privacy laws, looking through a tort kind of opening or through that paradigm, hopefully it'll start making sense what I mean when I use the term tort. So what you may want to do is listen to this presentation, then go back and look at this definition of tort, and I think you'll have a better sense as to where I'm going with it. At least I hope you will. Of course, if you have questions about this, if it's still not clicking at the end, please come see me. I'll be glad to talk in more detail to help hopefully elucidate this concept a little bit better for you. So privacy, we've talked about from a constitutional standpoint, we talked about it from a statutory standpoint, but long before we had our U.S. Constitution, long before we had any statutes in this area, back when we were a colony, or perhaps even earlier than that, before there were even Europeans in America, back in when people, perhaps many of our ancestors were still in England, we had this idea of privacy. It existed in the common law. And so we had this idea that somehow or another, if somebody gets too much into our business in some way or shape or form, that they may have committed a tort. And so these ideas have existed in our common law tradition literally for hundreds of years. So how does a court approach this? Well, one of the first things that the court's going to consider or think about is, what is the legal framework? What is the paradigm? What is the particular type of tort that is being alleged here? And once that particular type of tort is understood, and we'll go through several in a few minutes, but once that, whatever that tort is, once it's identified, then the court will say, well, what are the requirements to prove that that tort has happened? And so then a plaintiff will go through the requirements for that particular tort and explain the evidence that he or she has to support that particular claim. It becomes a very case-by-case, very fact-specific inquiry. But you first of all have to start with an understanding of what is the particular tort and what has to be proved for this particular tort. So now we're going to get started on a list of torts. This list is not intended to be exhaustive. These are kind of the best hits or the biggest players in this area. But one thing about tort law, and really all of common law, is that it's constantly evolving. It doesn't evolve quickly, but it does evolve over time. And so the way tort law looked in privacy 200 years ago would be different than what it looks like today. And how it'll look 200 years from now will also be different than how it looks today. And so there can be evolutions that are slow and steady, and there can be some times where there's dramatic changes in over a 10-year period. And so I'm giving you a snapshot generally of where we are in this area. So we're going to really focus on 4 particular privacy torts. The first is intrusion upon seclusion. This is my favorite. I love the name of it. It kind of rhymes. And so, but what is intrusion upon seclusion? The name itself kind of suggests what's going on. An intrusion is kind of an invasion, right? Somebody is pushing their way into your particular space. And so this is a wrongful invasion which must be objectionable to a reasonable person. So we have kind of 2 elements here, well actually 3 elements. There's an invasion, so somebody has come into an area that should be private, and that it's wrongful. The person who's kind of pushed himself or herself into the situation didn't belong there. And then finally, this intrusion has to be objectionable to a reasonable person. Now, we've already considered this term reasonable under the discussion of reasonable expectation of privacy. And I said how the word reasonable really is code word in the law for objective. Whenever you see reasonable, your first thought ought to be objective, meaning that this is not what you think is reasonable or okay. It's not what I think is reasonable or okay. It's kind of what an average of, you know, people think generally. What an average person in our society who's disinterested, who has no particular dog in a particular fight, who's has average intelligence, average education, average income, how would that person look upon this? That's how we kind of define that reasonable person. So you have to have all three things. You need to have an invasion that is wrongful and that would be objectionable to a reasonable person. Texas does recognize this tort, and here we have a little bit more clarity about, here we have the prima facie case for a tort of intrusion upon seclusion. It must show that the defendant intentionally intruded upon a private area. The plaintiff was entitled to privacy in the area. This is where we get the wrongfulness. And that the intrusion was objectionable to a reasonable person. So here's 1, 2, and 3. So as you're preparing, just keep in mind these 3 requirements. Now, because our tests are true or false or multiple choice, you don't have to commit to memory. I'm not going to ask you to repeat the 3 elements for intrusion upon seclusion. It's enough that you be able to recognize it when you see it. This particular tort, Texas courts have recognized, so you're good to go for this tort in Texas if you're the plaintiff. And that means that employers need to be concerned about this. So an employer that intentionally intrudes upon a private area and they would be objectionable to a person of reasonable sensitivity, that can cause an action or a legitimate cause of action in Texas. And again, here's another way of looking at the same thing. Plaintiffs must show an intentional intrusion has occurred. The object of the intrusion was truly private, so this is that wrongful requirement, and the intrusion would be highly offensive to a reasonable person. So we have all 3 of our elements here. It's just a different way of looking at it. Okay, so an example of an intrusion upon seclusion would be, let's say that my employer has a locker room. Maybe there's a fitness center in it, and there's a men's locker room and a women's locker room. And in the locker rooms, people shower, they change clothes, and if the employer, say, became concerned that people were stealing things maybe from other employees in the locker room. Maybe I might leave my my purse in the locker room and it's been missing. And so the employer gets the brilliant idea to put a camera up. Well, that captures people in all different states of undress. That would be an intrusion upon the seclusion because it is an intentional action. It's not accidental recording, it's planned recording into that private area. And it is true that the plaintiff, all those employees who recorded, would have entitled to privacy when they are changing clothes or showering. And that certainly that intrusion would be highly objectionable to a person of reasonable sensitivity. You know, there might be a few people out there that are body proud who wouldn't care about them being shown on that video, but that's not the usual person. Most of us would be very concerned and upset if we discovered that we were being taped when we were not dressed and we weren't aware that this was happening at the time. Okay, so that's our first tort, intrusion upon seclusion. Let's consider our next one. This is public disclosure of private facts. Now, the first thing to note here is that Texas does not acknowledge this particular tort. Now, again, I said before that this is a moving target. Who knows where Texas will be in 10 years? Maybe they will adopt it. Maybe they'll never adopt it. Right now, at least based upon my most recent research, it is not a tort that's going to be successful in Texas. Now, our textbook is a national textbook, and you may well find that if you are work for an employer that has offices in a variety of locations, that you may be supporting units that aren't in Texas. And so I'm not going to focus exclusively upon Texas law in this area, and I'm not going to take out all the questions that might include a public disclosure of private facts. When you see a scenario like this one right here, and it doesn't mention anything about Texas in it, then what you ought to do is assume that this isn't Texas. And so you shouldn't think to yourself, oh gosh, this is a public disclosure of private fact scenario. We're in Collin County, Texas. Texas hasn't recognized this tort, so therefore I shouldn't claim, or I shouldn't choose the choice that says it's a valid claim. No, unless I give you information that tells you it's Texas specific, you ought to assume that it's in a state that has recognized this particular tort. So let's go through an example to see what I'm talking about. Mary finds that Bob, her friend and supervisor, keeps in his desk drawer photos of her in a revealing bikini that she wore when they hung out at Bob's backyard pool one weekend. She asked Bob to return the pictures, but instead, Bob emails the pictures to other individuals in the unit. This has caused people to reach conclusions that maybe Mary and Bob had some kind of personal relationship, or Mary's a floozy or something like that, when in fact, no, it was just a normal, wholesome thing. Mary just happened to have that swimsuit. She put it on, and that's what she wore. But it wasn't in a public place. It was in a private backyard. She wasn't doing anything unusual in that situation, even though it might appear that she was, behaving in a public way, in a way that might be revealing or tacky or something like that. In a state other than Texas, Mary does likely have a claim for public disclosure of private facts. Now again, in the question, I'm not even going to include this in here. It's just going to say Mary has a cause of action for public disclosure of private facts, because there's nothing in this fact pattern that tells you it's happening in Texas. So be on the lookout for that. If I add something about Texas, that's when you need to know. Let's say I said, in Texas, Mary and Bob live in Texas. And then I go on to say, well, then there'll be some choice that says, Texas hasn't recognized this particular tort. So be aware of that. And you'll see that throughout these examples. Mary finds that Bob, we've already done this one, so we don't need to do this one again. Mary and Bob are coworkers. Mary overhears Bob's telephone conversation and unfortunately learns that Bob has leukemia. Mary shares this information with her coworkers. You know what? Maybe Mary does it because she's concerned about Bob. Maybe she has the very best of intentions, but still it's information that Bob preferred not to share. Under these circumstances, Mary likely has committed the tort of public disclosure of private facts. Again, not in Texas, but the way you ought to answer this question would be for all the states who have recognized this particular tort. Now, of course, if Mary were working in HR or she was Bob's supervisor, there would be additional statutes that would be in play. We'll see that in the next scenario. So Bob left an employee's private medical files on his desk. Maybe Bob's in HR, maybe he's a supervisor. These files fell on the floor. The entire office learned that the employee, we'll call the employee Fred. Fred has AIDS. The employee, Fred, did not want anyone to know about his medical condition. Under these circumstances, in a state that recognizes this tort, Bob has committed the tort of public disclosure of private facts. Now you can see in all of these cases, the disclosure was accurate. The fact that disclosed was in fact a true fact. So we're not in a situation where there's any lies or accidental misrepresentation. It's simply the fact that a truthful statement about a private fact has been made. Now when Bob is in a supervisory role or he works for HR, there are also Americans with Disabilities Act issues, and there can also be potentially, depending upon Bob's role, HIPAA issues in these particular cases, or GINA issues, Genetic Information Non-Disclosure Act issues. So again, there are some statutes in play here when we're talking about health conditions especially. Larry was upset that Bob, his supervisor, was giving him a poor performance appraisal. Larry then posted a copy of Bob's criminal record on the employee board in the cafeteria. Under these facts, Bob does not have a claim for public disclosure of private facts because guess what? Criminal records are public information. Obviously, Bob is very disturbed about this. He's embarrassed. It may negatively impact his career, but they're not really private facts, so he's out of luck in that sense. Now, just because Bob can't sue Larry, this doesn't mean that Bob can't fire Larry, of course. Bob absolutely can fire Larry, and Larry would really have no recourse under these circumstances because Larry presumably is an at-will employee. So the fact that Bob can't successfully sue doesn't mean that he can't fire. Let's consider Lucy's situation. Lucy works for a religious bookstore. She had an abortion when she was 16. Mary, a coworker, discovers this fact, and she reveals the fact to her and Lucy's coworkers, and as a result, they're very concerned, and she's ostracized at work. In a states that recognize this court, Mary does have a viable claim for action against Mary for public disclosure of private facts, despite the fact that Mary had no financial incentive to disclose Lucy's past. Because Mary isn't financially benefiting from this, she's just, I guess you could say, gossiping under these circumstances. And so there would be a claim, again, not in Texas because we don't recognize this tort, but in other jurisdictions. So here are the torts, or here are the elements of the tort. Public disclosure has occurred. The disclosure involved facts that were truly private. So things like medical diagnoses, medical procedures being done, things like that are classic examples of private information. The disclosure would be highly offensive to a reasonable person. The disclosure was intentional. Now you can say this is a bit iffy here. We're going back to this scenario. The files fell on the floor. So you could say, is that really intentional? That could be a little bit iffy. The matter disclosed was not of legitimate concern to the public. And again, that's with a criminal record, you could call that a matter of legitimate concern to the public. Let's say that, going back to our scenario, let's say that instead of this being an employment situation, but Fred, the employee who had AIDS, is running for political office. Well, a diagnosis of AIDS is pretty serious. A person who has that condition may not be ready for the rigors of political life. He or she may not be healthy enough to handle all of the responsibilities that come with that. And so under those circumstances, it probably would be an issue of public interest. And so if that were the findings, then even though it meets all the other qualifications for this tort, because it is a matter of legitimate concern for the public, it would not be the tort public disclosure of private facts. And again, just to repeat, Texas does not recognize this claim. So in Texas, we don't even have to worry about this. But I want you to be aware of it simply because your employer may well have units outside of the state of Texas. So now we're up to our third tort. So we've talked about intrusion upon seclusion, and we've talked about public disclosure of private facts. Now we're ready for our third tort, which is placement in a false light. When I say this, I'm not talking about taking a picture with the light in the wrong place or something like that. What we're talking about is a disclosure of a fact that is technically true, but it creates the impression in the reader or the seer that facts are different than what they truly are. Imagine a headline that says, child rapist captured, and they have a picture of a man. It looks like a mugshot directly below it, between the headlines and the article. The clear impression would be that the picture that is shown there is of the person charged with child rape, something that would be obviously very, very awful to have associated with you. When you read the article, you learn, though, that that picture wasn't actually of the person charged with child rape, but it was the only available picture that the newspaper could find of the father of the victim of the rape. The father had been charged with driving over the speed limit, and he had been arrested, and so there was a mugshot available for him. And so the newspaper decided to run that, because that was the picture they had of the gentleman. But it created the impression in a casual reader that that person with that face is the person charged with childhood rape or child rape, when in fact he is the father of the victim. Even though nothing in the article says that that picture is the picture of the child rapist, the average person would draw that conclusion. That would be an example of placement in a false light. So let's look at the publication of false light requirements. There is a public disclosure of facts that place the employee in a false light before the public. And the false light would be highly offensive to a reasonable person, and the person providing the information must have had knowledge of or recklessly disregard the falsity or false light of the publication. So again, there has to be basically the definition satisfied. It has to be highly offensive, and the person had to have had some reason to realize that would be offensive to that person. Here's an important thing to keep in mind when we're looking at this from the employee's perspective, and that is if the employee publishes the information or willingly permits it to be published, he or she isn't going to be able to advance a claim of placement in false light. I researched this issue for Texas law, and I was not able to find a definitive answer on this, but it does appear that probably Texas would recognize this particular claim. So let's consider an example of how this might play out. Lucy openly talks to her coworkers about her intimate liaisons with certain clients of her firm. Lucy's supervisor comes to know about this behavior, and during her performance appraisal, he mentions that her behavior can harm the reputation of the company. Hey, you having these sexual relationships, if that gets out, that could tarnish the reputation of our whole organization. Let's say Bob puts something into the performance appraisal, and that performance appraisal gets reviewed by more senior people. Lucy believes that when senior officials learn of the performance review with that information, it will project her as a woman of questionable morals. So she finds it, going back here, to be highly offensive. And she's probably right that it is highly offensive. But in these circumstances, Bob has not committed the tort of publication of false light for a couple of reasons. For one thing, I don't know that he's really presented it in a false light. It sounds like it's behavior that describes accurately what she's been doing. But more importantly for our purposes, since Lucy told people of it herself, she's not going to be able to successfully say, gosh, I didn't want this to come out. Well, if you didn't want it to come out, you shouldn't have talked about it. So under these circumstances, Lucy is not going to be successful with this claim. Now we have our fourth one, which is appropriation of a name or likeness. Let's look at the elements here. To prove a prima facie case of appropriation of plaintiff's name or likeness for commercial purposes, the plaintiff must show that the defendant used his name or her name or likeness for commercial purposes without being authorized to do so. And Texas does recognize this tort. Let's say that there is a photograph out there of Angelina Jolie. It's something I've been able to buy rights to use it. And it's clearly her face. And I want to sell let's say I have a makeup line. I want to sell my makeup line. And I think if I run advertisements showing Angelina's face, the general public will say, well, gosh, Angelina Jolie's beautiful and famous and she uses this makeup. Well, gosh, I want to look like her. And so they go out and buy the makeup that I have used Angelina Jolie's face for. So you can see I used her name or likeness for commercial purposes, and she did not authorize me to do this. So under those circumstances, her name and likeness has been appropriated. And so that would be an example of this tort. Texas does recognize this particular tort. I actually have kind of a funny story about this. I had, this is back in my days when I was working at JCPenney. Anyway, there was a hotline that existed, and because even though I was an employment attorney, I was also kind of the designated attorney for the catalog division. And so when customer service calls came in to the switchboard and the switchboard decided that it was a legal issue, it would be routed to me for me to handle. Anyway, I was there I guess I was kind of late at night. I'm not sure why I was there. But anyway, I answered the phone, and the call was forwarded to me. And a woman started speaking to me. She was very nice and pleasant. She started by saying, listen, I have a concern. I was looking at the catalog I just received in the mail, and there's a picture of me in the catalog, and I did not approve this picture. Now that seemed very strange to me because we don't just, JCPenney didn't randomly take pictures of people, but I thought, well, I mean, probably someone looking like her or something like that. And so I said, well, okay, describe to me what the catalog looked like. And so she described the cover of the catalog. And so I went to, literally JCPenney in a year created 100 or more catalogs. So I went to the big catalog room and pulled out the catalog that she was talking about. I found it, and so I said, so what page? And she said, well, the pages aren't numbered, but it's this particular page. So I turned to that page, and she said, it's this particular item. She gave me the SKU number. So I look at it, and I realize it's just the picture of a woman's foot inside a shoe. And there was no distinguishing characteristics of the woman. It seemed to be a Caucasian woman, but other than that, and it didn't seem to be, say, an old woman or a child, but anyone in her, say, 20s through 40s could have easily been her foot, any woman who was Caucasian. It was an attractive leg, but there wasn't anything particularly unusual about the leg. And so I said, well, ma'am, how do you know this is your leg? And she says, well, good question. I used to work for JCPenney, and when I came to work there, I signed a form saying that they could use my picture for various and sundry purposes. I found that kind of a strange statement, but I thought, well, maybe this particular unit might have had a newsletter or something, and so they might post, the birthday list or something with people's pictures on it or whatever. So, and she says, and I haven't worked for JCPenney in many years, but I know it's my leg because my boyfriend took a picture just like this of my leg, and we recently broke up. And I'm sure that he mailed it to JCPenney, and JCPenney decided to publish it and also decided to start selling the shoe. Anyway, at this point, I clearly recognized that this lady was crackers, and so I politely spoke to her, but I understood that she was not dealing from the top of the deck, so to speak. So her case was not so good. But if we had in fact, or if JCPenney had in fact taken her picture without her consent and put it in the catalog, then she certainly would have had a claim in Texas or any other state. She wasn't from the state of Texas, but the state that she was from. Here's a summary about how Texas law works in this area. And you can see the only one of the 4 theories that we've talked about that Texas doesn't recognize is the public disclosure of private facts. I give you the cases where this was discussed. Don't worry about knowing the cases or the years or anything like that. Okay, now we're going to move on. We're going to not really touch on the breach of contract type of claim, even though that can arise in a privacy context, but we're going to flip to intentional infliction of emotional distress. This is not traditionally a privacy issue. Let's go through what the elements are, and then we'll talk about it a little bit from this context. Plaintiffs must show intent to harm, behavior that is so outrageous, shocking, or atrocious as to be beyond the bounds of what is tolerable in a civilized society, and severe emotional harm or distress. I'll give you an example. And usually the facts have to be really extreme to be successful, at least in the state of Texas on this claim. So imagine that I decide I want to prank you. And I call you up, and we're friends. We've known each other forever. You trust me when I say things to you. And I happen to know that your mother has been in poor health. And I happen to know your mother and have some connections with her. Anyway, I call up you and I say, I'm so sorry to hear. I just heard 5 minutes ago that your mother passed away, and I am just so sad for you. And you believe that I know that your mother has passed away, and you thought your mother was still alive. You hadn't heard this news. And so you're just incredibly distraught, distraught that your mother has passed away, distraught that you haven't been notified, and you are just very, very upset. And then I say, April Fools, and that would be a classic case of intentional infliction of emotional distress. Now that really isn't a privacy aspect, but you can see how it could be a privacy aspect. For example, I might have said, um, I uh, I figured out your password to your Facebook account, and I posted some things. Let's say I posted some, hey, I like Nazism, or I'm a white supremacist, or whatever the crazy thing might be, and so I am doing that and that could be an example of intentional infliction of emotional distress. And because I hacked into your Facebook account or whatever your account might be, that could be a privacy issue as well. So you can see intentional infliction of emotional distress claims in the privacy context. Generally, though, these are hard claims to prove, especially in Texas, but just generally. It has to be pretty severe circumstances. Now we're going to flip and talk about defamation. Defamation is another type of tort type claim. It is not usually thought of as a privacy issue, but it can have privacy implications. So let's look at what the prima facie case, or what the elements are for a defamation claim. Okay, the plaintiff must prove, or in this case the employee plaintiff must prove, that the statements made were false and defamatory towards the employee. So in order to have a defamation claim, it has to be wrong. If somebody's saying something that's true about you, even if it's hurtful, even if it causes you a financial loss, that's not going to work for a defamation claim. It has to be false, factually wrong. And it has to be communicated to a third party. We call this publication. Actually, this should be up here. Communicated to a third party. So somebody other than, let's say the employer is the one defaming the employee. I can't defame you to your face because you're not a third party. But if I say, I say that you stole from my company to somebody else that isn't you, then that potentially can be defamation if the statement is false and I did in fact communicate it to a third party. And you didn't give me consent to do so, and finally you experienced harm as a result. So let's consider Lucy. Lucy's been up to a lot of stuff during this particular lecture. Lucy was fired by Eager Beaver Mart because she stole from the cash register. So we're accepting this as fact. She definitely stole from the cash register. The Mart filed a police report because obviously she stole. A prospective employer subsequently calls Eager Beaver Mart for a reference check for Lucy, and a Mart employee tells the caller that Lucy was fired for stealing. This is a true statement. Of course, the telling the caller this information, in this scenario, the caller would be a third person. And certainly Lucy did not give her consent to the Eager Beaver Mart telling the caller this. And certainly it caused harm to Lucy because obviously the employer, the caller isn't going to hire Lucy. So we've satisfied 2, 3, and 4. The problem for Lucy is this top one. Because it was a true statement, it can't be defamation. There's an expression in law that truth is a complete defense to defamation. Let's look at another scenario. Bob worked for Farmersville City Bank. He left the company voluntarily after he entered a personal relationship with Mary, the branch manager, who was his boss. When a prospective employer contacted the bank for a reference, so this is going to be our third party, so this is where we're going to have publication, Mary told that employer that Bob had been fired for misconduct. This is a big fat lie. Bob did not get the job, so he has a financial loss, and he certainly didn't consent to this. So it's a false statement that Mary gave the potential employer. It was communicated to that potential employer. Bob didn't consent to that publication, and it certainly harmed Bob because Bob didn't get the job. So we satisfied all of the requirements for the tort of defamation. So Bob does have a claim of defamation. Defamation is actually a large concept that can be broken down into two subconcepts. One is libel and one is slander. They are both flavors of defamation. So if you kind of want to think about it, you can think about defamation as being the concept ice cream. And then you might have chocolate ice cream and you might have vanilla ice cream, or maybe you have Rocky Road or pistachio or whatever. But anyway, these are the only two flavors that defamation comes in. So what is libel? You can see here that libel starts with an L. We like to think of this as lasting letter. Libel is much more serious than slander. So think about that L start for libel and just remember lasting letter. Because it's permanent. If you write something, it can be given to lots of different people and communicated in lots of different ways. It's hard to make libel go away. Slander is still a defamation, but it's a less serious defamation. And this is spoken. You can see again, we see the slander starts with an S and spoken starts with an S. Now, some types of libel can be spoken. If it's recorded, then it's lasting. So we don't care about the fact that it's spoken, because the idea here is that slander is transitory. If I tell you something, in both of our examples we were talking about slander, obviously, because Mary isn't reducing this to a letter. But if she instead wrote a letter to the potential employer and had told the lie, then we would have a libel case. But because Mary just spoke the slander, spoke the defamation, we have a slander case. Let's talk about the topic of compelled publication within the context of defamation. Before we get started, let me tell you, this theory does not work in Texas. And my guess is it doesn't work in probably about half of the states. There are definitely states where it does work, but this is by no means a for sure scenario. Again, when you see these questions, don't assume that it's in a Texas context, okay? So, what is compelled self-publication? Let's go back to our story with Bob. Let's say that Bob decided to, let's say that Bob did not resign. He was fired. And Mary fired him and told him when he fired him, she told him when she fired him that she was firing him because he had embezzled $100,000. Well, Bob says, but that's not true. I haven't embezzled $100,000. She goes, that's what the documents show. That's the reason I've told everyone. And that's what the paperwork will show, that you embezzled $100,000. So Bob goes to an interview, we'll say at Plano City Bank. He goes into the interview and he's asked, well, why did you leave Farmersville City Bank? And Bob says, well, I was terminated. My former supervisor, Mary, claims that I embezzled $100,000. I didn't. She fired me because I broke off a personal relationship with her and she was angry about that. I never stole anything from Farmersville City Bank, but that is what she will tell you if you call her. So in that situation, Mary hasn't said anything. Plano City Bank has not even contacted Mary. So the ordinary elements are not here. Mary hasn't made any statement against Bob other than what she told Bob directly, and we already know that can't be defamation. She has not communicated it to a third party such as Plano City Bank. In this case, I guess in some sense the employee has consented to this because he's actually saying it. No one's putting a gun to his head and making him say these words. Obviously, Bob is not going to get that job at Plano City Bank, so certainly he has experienced a harm, but generally speaking, under the prima facie case or elements of the defamation, Bob's not doing so great. He is not going to be successful in his defamation claim. But in some jurisdictions, there's something called compelled self-publication. And so this kind of solves Bob's problem. Let's look at what compelled publication is. Again, it doesn't work in Texas and many other places, but where it does work, let's see how it does work. When an employee, I'm sorry, it should be employee, not employer. When an employee is left with no choice but to tell a prospective employer the defamatory reason for his or her discharge from a previous employer. I mean, when Plano City Bank says to Bob, well, Bob, why'd you leave Farmersville City Bank? Bob doesn't want to lie. He has to, or he's going to, as a matter of character, say what Mary told him. He's going to also say, well, that's not true. But is Plano City Bank willing to take a chance, especially if they don't know Bob? No, very unlikely. Another reason that Bob is going to feel that it's necessary for him to tell the truth is that he knows that probably Plano City Bank will call Mary and find out what Mary's story is. And so if Bob says, oh, I just resigned, I was tired of working there, and Mary goes, well, actually, we fired him because he embezzled money, any chance that Bob might have had the job just went poof. And so compelled self-publication, especially when somebody is terminated from a job and then seeks employment with somebody else, that can be one way of approaching. Again, don't think it's going to work in Texas. The case law just isn't there for it. The Texas Supreme Court has ruled against it. But again, common law evolves. In 20 years, who knows where the law will be under these circumstances. So let's consider this scenario. Bob was accused of misappropriation of company funds, a charge which he vehemently denied. The company fired him without having any proof. When he applied for other jobs, he naturally had to explain to the employers why he was fired from his former employment. In this case, Bob can file an action against his former employer for compelled self-publication in jurisdictions that recognize this claim. Again, there's nothing in this fact pattern that says Texas, so you would, if you were presented with this test question, you would say, yes, this is an example of compelled self-publication. Here is we'll talk about this little tidbit, then we'll actually pull up the statute here. In Texas and many other states, I think it's most states, there is a statute that exists that is intended to give employers some protection when employers give references for their current or former employees. Let's see what the text here says. An employer is privileged, we'll talk about what privilege means in a second. An employer is privileged to make statements, even if otherwise defamatory, where the statement is made in good faith by one who has a legitimate business purpose in making the communication to one who has a business interest in learning the information. So let's say that Bob has come in for a job interview. He hasn't told me, let's say there's actually some evidence that he did misappropriate company funds. You know, not a smoking gun, but some evidence of that. We just didn't want to take the risk of continuing Bob's employment. A few years have passed, and honestly, I've forgotten the details of how Bob, you know, how strong the case was. I do remember we fired him for theft. I don't remember how strong or weak or the particulars of the facts are. So I get a call from somebody who's seeking to hire Bob. And as they say, hey, tell me about Bob, I'm going to say, you really don't want to hire him. I mean, he stole from us. I don't remember the specifics. It's been several years, but I mean, if I were you, I would just run away from this candidate. So naturally, the employer is not going to hire Bob. It ends up that really we had very little evidence, but this is an at-will state. So, you know, we don't have to have a good case to fire somebody. We can just say this isn't a good fit. We have a little bit of evidence you might have misappropriated funds, so we're going to end the relationship. Did I defame Bob by saying that? Very possibly I've satisfied all the elements. But the statute, which I'm about to show you, is going to say, well, if I said it in good faith to somebody who had a legitimate business interest in knowing it, my statement is going to be privileged. It's going to be a qualified privilege, though. So when we talk about privilege in the law, this is when the law says we're kind of making an exception to our usual rule. We're going to allow, because of the particular circumstances, we're going to allow you to kind of, in a way, get away with more than you usually would be able to, because we think it's socially useful to have these conversations. Think about it. Imagine that instead of us being a bank, that this was a daycare center. And let's say that we fired somebody for being abusive to a child, maybe shaking a baby. And so another daycare, so we fire the person, then this person seeks employment in another daycare. Don't we want the first daycare to be able to tell the second daycare, don't hire that person. She shook a baby. Baby's going to be okay, but it was not a good situation. You don't want to take that risk. So having those conversations can be very socially useful. And so that's why we have a privilege in this area. Let's go ahead and pull up this particular statute so we can see exactly what the parameters of this qualified privilege is in Texas. Here, I've pulled up the labor code here. This is the rule. I'm going to, sorry, meant to go the other way. Okay. Immunity from civil liability employer representatives. An employer who discloses information about a current or former employee under this section is immune. That's that privilege ID. Immune from civil liability for that disclosure or any damages proximately caused by that disclosure unless it is proven by clear and convincing evidence that the information disclosed was known by the employer to be false at the time the disclosure was made, or the disclosure was made with malice or in reckless disregard of the truth or falsity of the information disclosed. For purposes of this subsection, known includes actual knowledge based upon information relating to the employee, including any information maintained in a file by the employer on that employee. This chapter applies to a managerial employee or other representative of the employer who is authorized to provide and who does provide information in accordance with this chapter in the same manner that it applies to the employer. So what is this clear and convincing evidence standard? Well, we usually think of there being two main evidentiary standards in the law. The first we know from criminal law, most of us have heard of beyond a reasonable doubt. That means that you can't convict someone of a criminal offense if there is any reasonable doubt. Now, it's hard to put a percentage on what reasonable doubt is, but most people think it's more than 90% sure that this person committed the crime. That's not the standard we use in civil cases. The standard we use in civil cases is preponderance of the evidence. That means that it's more likely than not to be true. So we're thinking 51%. You can see there's a huge difference between the civil standard preponderance of the evidence and the criminal standard beyond a reasonable doubt. There's a middle standard, kind of halfway between those two, and that is the clear and convincing evidence standard. It's not used that commonly. There are a few issues that it's used in the criminal justice system, although usually, again, it's beyond a reasonable doubt. And then there are a few areas where it's used in the civil system. Obviously, in this context, we're talking about a civil system. There isn't a particular percentage I can assign to it, but usually when you read the cases, it says that the jurors have a settled feeling that it happened a certain way. Sometimes people think about 75 or 80% chance. It's not as strong as beyond a reasonable doubt, but the person thinks, yeah, I really do think it happened this way. I'm not so sure that I'm going to be shocked if it didn't happen this way, but I really do feel that that's the way. So it's a higher level of proof that the plaintiff has to bear than he does in an ordinary case. So you may be thinking, if I'm the HR professional or I'm advising an employer as a paralegal supporting the HR function, how does this impact what I say? Well, first of all, smart employers do not give subjective references for their current or former employees. That's just not a smart strategy. The the person giving the reference for the current or former employee, are getting nothing out of it. right? I mean, if you give a good reference to your current employee, it makes it more likely that that employee will leave. That's not a good thing. If this is a former employee, you giving a good or bad reference is not going to help your business at all one way or the other. It could help that other business, but that other business might be your competitor, so why do you want to help them? So there's really no upside in terms of kind of self-interest for you to be giving references at all. But there is this downside that you have the potential to have civil liability. So this statute provides some level of protection, but it's not magic pixie dust that somehow protects you from any possibilities. Because again, maybe there will be clear and convincing evidence that you defamed this person, or at least the jury is persuaded about that. So why take the risk to begin with? As a result, most employers do not give references except kind of, date, rank, and serial number, or things like that, age, name, rank, and serial number. So things that employers oftentimes will give are dates of employment, last position held, pay rate at the time of last position held, and some employers will give whether the person is rehirable or not. Because again, saying, yes, this person is rehirable, this person is not rehirable, I mean, that's just a fact one way or the other. Now, I suppose if the person is rehirable and you say they're not rehirable, then that could be a defamation type position. As soon as you start getting into subjective things, though, you are in a difficult situation. Let's say that you have a former employee, though, you really want to help them out. They were a good worker. And so you say, listen, I don't see how this can hurt me. I'm going to say good things about this person. And so you agree to be a reference for this particular person. You get a call from a future employer and they say, tell me about Bob. And you go, Bob was great. He was hardworking, he was smart, he was conscientious. I mean, the whole 5 years that he worked here, he probably resulted in so much, huge growth in our business. And I'm just so pleased that Bob was our employee. Now, the prospective employer says, oh, wow, he sounds great. What was Bob's greatest weakness? Well, gosh, he was so awesome. I don't really know that he had any weaknesses. I mean, he was late a few times to work. But, I mean, not a lot, and it wasn't a big deal. I mean, the nature of our business is it doesn't really matter so much when you show up. It matters how much work you do for that day. Well, that employer that you were just talking to might say, oh, well, for my business, being on time is absolutely essential. If Bob was late sometimes, I'm just not interested in hiring him. So you see how what sounded like a really, really positive appraisal could end up really coming to cause that person not to get the job. So better to have that neutral reference policy where you give just cold, hard facts, no types of opinions or subjective evaluations. Okay, so let's go back to our slides. And we are now done. So we have covered the topic of common law issues. And when we are next together in the next broadcast, we will cover some special issues that can relate to privacy issues, such as when the employee has off-duty activities that the employer does not approve of, when there needs to be an investigation of something that happened in the work environment, and when the employee's personal property is somehow in play in a given situation. We'll see some scenarios along those lines. And then finally, we have the big issue that we haven't talked about, and this is a huge one, employee monitoring. What can an employer do in this area? What should an employer do in this area? As always, I thank you for your attention. If you have any questions, please don't hesitate to reach out to me. My email is cgroover@collin.edu. I would love to hear from you. Alternatively, please stop by my office hours. I would also love to meet with you to just explore these issues in more detail. I thank you for your attention, and I hope you have a wonderful day. Thanks so much.